13 my lord.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರನ್ವಯ ರವೀಂದ್ರ ತಂದೆ ಮಹಂತಪ್ಪ ಸೇವಕ ಸೇಠ್ ಗೋವರ್ಧನ ಲಾಲ್ ವರ್ಮಾ ಹಿಂದಿ ಪ್ರೌಢ ಶಾಲೆ ಶಹಾಬಾದ್ ಚಿತ್ತಾಪುರ್ ಇವರ ಹುದ್ದೆ ವೇತನದಾನಕ್ಕೆ ಒಳಪಡಿಸಲು ಕುರಿತು ಸಲ್ಲಿಸಿರುವ ಪ್ರಸ್ತಾವನೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಪ್ರಸ್ತುತ ಉಲ್ಲೇಖ 2ರನ್ವಯ ಮಾನ್ಯ ಸರ್ಕಾರ ಅಪರ ಮೂಲ ಕಾರ್ಯದರ್ಶಿಗಳು ಆರ್ಥಿಕ ಇಲಾಖೆ ಬೆಂಗಳೂರವರ ದಿನಾಂಕ 16/6/2020ರಂತೆ ಹೊರಡಿಸುವ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಪ್ರಕಾರ ಅನುದಾನಿತ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಖಾಲಿ ಉಂಟಾಗುವ ಹುದ್ದೆಗಳಿಗೆ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ಹೊಸದಾಗಿ ಸಹಮತಿ ನೀಡುವಂತಿಲ್ಲವೆಂದು ನಿರ್ಧರಿಸುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸರ್ಕಾರವು ಸದರಿ ಆರ್ಥಿಕ ನಿರ್ಬಂಧ ಆದೇಶ ತೆರವುಗೊಳಿಸಿದ ನಂತರ ಪ್ರಸ್ತಾವನೆ ಮರುಸಲ್ಲಿಸಲು ತಿಳಿಸಿ ಯಥಾವತ್ತಾಗಿ ಹಿಂದಿರುಗಿಸಿದೆ. But we returned that and because there is a ban, or that is a reason thereafter Malad is not submitted. After Malad revoking that and all Malad, he is not, for that is the reason we issued the endorsement on Akshar Arts.
You are completely right, but the court is also right.
But that is true, Malad. During whichever Malad entitled, suppose government permit us Malad to give the grant. When they ban, he submitted the report, his proposal, so that was returned, requesting him to resubmit.
He has not sent is what you are saying. Correct. Now, court order has stay. What is the court order stated?
That is, my lord. Consider the representation.
It's not
in terms of the order. In terms of the order, letter 12/6/2020. 12/6/2020. 12/6/2020, my lord. That along with memo, my lord, it was produced, my lord. That, what is the direction? That,
no, section 131 of order is passed. Section 131 order is passed.
Yes, my lord. But that time it was passed, my lord. We are not disputing that one. For that is the reason, my lord, government directed us to include even second and third also.
Now all that has to be followed.
Yes, my lord.
And implemented.
But that time proposal was not there, my lord. Proposal not there. If there was a proposal, my lord, definitely his name will be included.
Right now we have.
But kindly see what is the order, my lord, 12, which is relayed by the learned single judge, my lord. That is, my lord, kindly see, my lord, that order.
But that before the single judge only you should clarify, not here.
And now, my lord, government is not permitting us. Not we are ready to give, but government is not permitting.
Court order is there.
Court order, my lord, that is.
Treat this matter as a special case, or else face the contempt. Charge ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ.
That is, my lord, that is the direction in persons of the order, my lord. That is.
Once there is a court order, there ends the matter. There is an order under 131 of the Education.
What is the order, my lord? Kindly say that is the order. What is the order, my lord?
Education Act order. What do you do?
12/6 order. That is learned single judge relayed the, my lord, order passed by the.
That you should have clarified there.
That is 12/6/2020, my lord. That was produced, my lord, along with memo, maybe, my lord. I will read, my lord, that what is the 12/6/2020.
Where is that produced at?
What he produced, my lord, that is. No copy there. But I will pass on, my lord. It is produced, my lord, it is there.
Put it.
This is, my lord, deputy director sent to the, my lord, sorry. Ban order date 2020 ಇಂದ ಇವತ್ತಿನವರೆಗೂ ಅವಕಾಶ
Read.
Please, my lord, I will read.
12/6/2020 is R3 in today's affidavit.
Yes, this is proposal, my lord. It is only proposal.
You read it.
Kindly, sir. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಮೂಲಕ ರವೀಂದ್ರ ತಂದೆ ಮಹಂತಪ್ಪ ಸೇವಕ್ ಸೇಠ್ ಗೋವರ್ಧನ ವರ್ಮಾ ಹಿಂದಿ ಪ್ರೌಢ ಶಾಲೆ ಶಹಾಬಾದ್ ಚಿತ್ತಾಪುರ್ ಇವರ ಹುದ್ದೆ ವೇತನದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಸಂಬಂಧ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದ್ದು, ಉಲ್ಲೇಖ 2ರ ಮೂಲಕ ಮಾನ್ಯರ ಸದರಿ ಸೇವಕರ ಹುದ್ದೆ ವೇತನದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಸಂಬಂಧ 7 ಅಂಶ ಅಗತ್ಯ ದಾಖಲೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿ ಪ್ರಸ್ತಾವನೆ ಹಿಂದಿರುಗಿಸಿದ್ದು ಇರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ಉಲ್ಲೇಖ 3ರನ್ವಯ ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳು ಚಿತ್ತಾಪುರ ಅವರಿಗೆ ಸದರಿ 7 ಅಂಶಗಳ ಅಗತ್ಯ ದಾಖಲೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿದ್ದು, ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿ ಚಿತ್ತಾಪುರ ಅವರು ಉಲ್ಲೇಖ 4ರ ಮೂಲಕ ಸದರಿ 7 ಅಂಶ ಅಗತ್ಯ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಪ್ರಸ್ತುತ ರವೀಂದ್ರ ಸೋನ್ಸೋ ಗೋವರ್ಧನ ವರ್ಮ ವಿಂದಿ ಪ್ರೌಢಶಾಲೆ ಶಹಾಬಾದ್ ಚಿತ್ತಾಪುರ ಇವರು ಸದರಿ ಶಾಲೆಯಲ್ಲಿ 2ನೇ ಗ್ರೂಪ್ ಹುದ್ದೆ ಮೇಲೆ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು, ಸದರಿ ನೌಕರರ ಹೆಸರು ಸರ್ಕಾರದ ಆದೇಶ ಪಟ್ಟಿಯಲ್ಲಿ ಸೇರ್ಪಡೆಗೊಳ್ಳಲು ಸರ್ಕಾರದ ಅನುಮತಿಗಾಗಿ ಮತ್ತು ಆದೇಶಕ್ಕಾಗಿ ಸದರಿ 7 ಅಂಶಗಳನ್ನು ಪ್ರಸ್ತುತ ಸಲ್ಲಿಸಿದೆ.
I'll tell you one simple.
Please.
Let's assume that for regularization, when a list is being sent, one of the employees' name is left out. And subsequently, he files a writ saying that when the department forwarded to the government list of proposed employees to be regularized, my name was left out. Some people earlier have already been regularized. Names have been sent.
That's true.
Subsequently, there was some bar in considering regularization. His case cannot be treated on the subsequent date because his name was left out due to not his mistake. Institution didn't send. Now, he cannot tell the institution, he cannot force the institution to send.
That's true.
So, what we are saying,
Please.
now in terms of R2, let's assume that his name was sent.
Yes.
It would have been cleared. So the fault lies with whom? Not with the employee, but with the institution.
Yes, that is, he has to claim against the
So,
institution. Yes.
for which you can't make him a scapegoat
That's
or
true.
liable.
That's
That's all
true,
we
my
are
lord.
saying.
Yes, that is, there is a direction by the learned single judge. Consider this proposal and you proceed. So kindly see annexure R4, my lord, in my affidavit, my lord.
No, it could be clarified.
That is a ban, my lord. Previous 2 days, my lord,
Correct.
it was
So we'll
banned.
we'll clarify that the forwarding of the name must be treated as if it was made in R2. And now suppose, let's assume under R2 if it was made,
Yes.
you would have done it,
Yes, my lord.
isn't it?
Yes, my lord,
You have
definitely.
to treat it as a case of his name having been forwarded as per R2.
That is true, my lord. But already that is filled, my lord. That whatever, my lord,
No, speak through your counsel.
you will permit, my lord.
Huh?
You will permit to speak. You will make some submission, my lord.
If you are confident that he will
He is additional commissioner, my lord. He is the authority, my lord.
tell us.
Sir, one submission is that
Come here.
the proposals that were sent to the government, sir, more than 100 proposals were sent to the government with respect to group Ds also, even with respect to other teachers as well. In that case, government looking at its expenditure capacity will restrict the number to only 100. So the top 100, the ones who had applied earlier to the candidate have gotten the grant, sir. So after 100, who are there, we've written to the government, and whenever the government gives us permission, then we can fill them accordingly, sir. That too based on merit list, who is appointed early and those who are there in the top in the merit list.
Now, Mallikarjun,
Please.
now this is your administrative exigency. No doubt that may be your administrative exigency. But however, we look at it simply like this, that he was eligible to be sent under R2. Let's assume his name was sent under R2. It would have been considered, isn't it? He was merit and he had seniority, etc.
Whatever it may be, we don't know, my lord. That time it was submitted, then only government will ascertain that one. That was not, because application was not there, proposal was not there. That is the reason, my lord. So many, my lord, excluded, even not only 100, my lord. So many people is submitted,
The
only
mistake
restricted
of-
only 100.
For the mistake of forwarding it. Now what happens in your government offices, including here also on the administrative side, they forward. You shouldn't forward. If the rule doesn't permit, you shouldn't have forwarded. You should say you must wait until the government reopens it, I won't forward.
But we'll send
Having
it,
made
my
the
lord.
recommendation.
We'll send it, my lord. If it is accepted and well and good. We are not, my lord, opposing, but complainant, my lord. Because of the ban order, my lord, they are directed us, don't send it. For that is that you will also direct us, my lord. Send this proposal to the, my lord, then we will send it, my lord. Let the, my lord, if it is, If he is very lucky, then he will get it.
That we can't sit and decide here.
That is the problem, my lord, because
May I make one submission, my lord? Humble submission. What my learned friend and learned respected additional commissioner is making submission that is contrary to records. May I bring it to your lordship's kind notice?
Yes.
They are producing right now, just now, the communications of 2020, 2024, etc. And whereas, my lord, in the year 2017 itself, that is 2016, much earlier to that, they had sent the proposal. The government has sent, the institution has sent for the proposal for including his name.
Sure.
Ade sir. Otherly, they did not do it.
Yes, sure.
Yeah, atta. Though I had kept it ready, my lord, but I felt that they will come fairly with the court. That apart, my lord.
At page,
One. Two and three typed copies at 3.
page 3.
House. I will, in short, my lord, I will submit for your lordship's kind consideration. They were not regularizing my service. It's for that reason, though they sent it for regularization, they wanted to appoint some other person in my place. Some frivolous grounds, they terminated me from service.
Yes, tell us.
My lord, I was ordered to be reinstated. They preferred writ petition, writ appeal. That is secondary, my lord. Thereafter, my lord, since they were not considering my regularization, I approached this honorable court. This honorable court directed me to approach 131. I approached 131. They did not pass orders. That was way back in the year 2016. Your lordship may kindly peruse the impugned order at ink page 14, para 2. His lordship learned single judge.
Page 14.
Page 14 of impugned order, my lord, that is contempt petition nulli. Page 14, my lord. It is not that they have been taken aback. Now they are trying to persuade your lordship that there was no proposal, etc., which is contrary to the records and their own submissions. Your lordship, the petition contains that he was appointed to the post of C group employee so-and-so, respond number 5 managed and administered by so-and-so as per Matant, and he was branded as temporary. The petitioner had moved application before the respondent number 1 for regularization of his service, also covering his post as permanent employee under the grantee aid. The respondent number 1, that is the principal secretary, did not consider his application. Therefore, he approached this court by filing the writ petition number so-and-so. I was, because of the attitude on the part of respondent number 1, I was compelled to approach this honorable court, get an order way back in the year 2017, that is 201961 of 2017. Coordinated bench of this honorable court by an order dated 30th May 2018 allowed the writ petition directing the respondent to number 1 to dispose of the petition said to be filed by the petitioner under section 131 of the Karnataka Education Act within a period of 2 months from the date. After, luckily, I am lucky, my lord, that they have passed the order following the directions. They will not be following. My experience says, my lord, that only after filing the contempt petition, they will be passing the orders. This is irony. And way back in the year 2017, it has been passed. And basing on that, my lord, your lordship, my kindly, the affidavit which I have filed earlier.
Now just
Otherly,
just take us for the present to the 131 order once again.
Ade thoughts. Your lordship. Now my memo dated 17/2, my lord.
Now page number
4, my lord. Your Lordship got it?
Yes.
Pradhana Karadarshigulu, that is the head of the education department. The ED number 396 of 2016. 2016 that was matter was pending, and when they did not consider it, I was forced to approach this honorable court, get an order of mandamus in the year 2017, that is 2018.
Just 1 minute. When was the ban? Which year was the ban?
21.
From when to when?
That is, my lord, that is Annexure R4, my lord.
Today's affidavit.
Page number 12, my lord.
Huh?
Page number 12, my lord, in my update, today's update.
Page number?
12, my lord.
So
Page
that
Annexure R4. my lord.
ban is from when to when onwards?
This is order is passed on 10/6/2020.
From 10/6/2020, there is a ban.
ಹೌದು 20 ಲಿಂದ ಅಂತ ಇದೆ.
Onwards,
Yes, my lord.
there is a ban. Correct. Now let's take a simple case. Order under 131 was passed on 15/10/2018.
Yes, my lord.
Just 1 minute. ಸರ್ಕಾರದ ಪತ್ರ ಸುನೀಡಿರುವ
Subsequently.
ಸಾರ್ವಜನಿಕ ಅಗತ್ಯ ಕ್ರಮ ವಹಿಸುವಂತೆ ಆದೇಶಿಸಿದೆ.
ಹೌದು.
So now, if on that date
Yes, my lord.
you had complied, what would have happened?
10/6 the ban, my lord. 12/6 the proposal.
15/10/2018,
Yes, my lord.
order is passed.
But that time, my lord, earlier my lord friend is saying that, my lord, that was sent. But that was not included because only they filled only 100 people.
On
That's all.
15/10/2018,
Right.
there's a direction to consider.
But that is considered but there is a direction to consider principal secretary 131.
Correct.
131 application is pending, my lord. For that is not passed any order, my lord. He approached to this honorable court. Direction issued to the principal secretary to dispose of the 131 section 131 application.
When did you dispose of? When did you
That is my
dispose
lord
that?
friend is produced that one, my lord.
When did you dispose it?
I don't know. That is there is no reference that writ petition order, my lord, in the principal secretary order, my lord,
There,
which my lord friend is relying that.
we should assist the honorable court.
Now that 15/10/2018, after that order was passed, when did you pass an order now?
But 201961 of 2017 is the writ petition, my lord. That
That was the direction
to the principal secretary to dispose of that
131.
131.
When did you dispose it?
That one, my learned friend has to say that one because he is relying that one, my lord. That's why there is no reference that writ petition.
It is your document 15/10/2018.
15/10.
Ink page 5.
Where is the reference of this?
We are
writ
here to
petition?
assist the honorable court, my lord.
We
And
are assessing, we are
it
not
is
suppressing.
whether me or government has more responsibility.
No, now, just 1 minute. Now, the 131 order was passed on
15/10, my lord, ink page 5.
15/10/2018.
Last lines.
No, correct. Now, then that was directed to be disposed of. When was it disposed of?
ಅಲ್ಲ ಅದೇ ಸರ್ 15/10 ಗೆ ಸೆಕ್ರೆಟರಿ passes the order.
No, the order is to take further steps.
My lord, this is the writ petition para 2 of the my lord, page number 4, my lord.
You go to this order passed by the appellate authority.
Yes, my lord. That is my lord, writ petition is
131.
referred, my lord. 84/861 of 2001.
No, just one. You go to the order of the appellate authority.
Please.
At page 4 of today's.
Yes, my lord. Page number 4, my lord.
17/2/25.
Yes, my lord.
Now you go to that.
Appeal application number 54 of 16.
Sorry, my lord. This is the order passed by the appellate authority 15/5/2009, my lord. Sorry, 15/10/2018, my lord. Para, my lord.
Last para, operative question.
Last line, sir.
Adesha.
Operative portion, Adesha. ಅಲ್ಲ ನಾನ್ ಕೇಳ್ತಾರ ಸ್ವಾಮಿ ಅದು ರಿಟ್ ಪಿಟಿಷನ್ ಏನ್ ರೆಫರ್ ಮಾಡ್ತಾರೆ
This order passed.
ದಟ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್ ದೇರ್ ಇಸ್ ನೋ ರೆಫರೆನ್ಸ್ ಅಂತ ನಾನು ದಿಸ್ ಈಸ್ ರಿಲೇಟೆಡ್ ಮೈ ಲಾರ್ಡ್ ಸಮ್ ಅದರ್ writ petitions, my lord, that is para number 3 of the order, my lord. Page number 4.
ಅಲ್ಲ ಆಯ್ತು ಯಾವುದೇ ರಿಟ್ ಪಿಟಿಷನ್
ಅಲ್ಲ ಯಾವ್ದಂತ ಗೊತ್ತಿಲ್ಲ. For what purpose they, my lord, pass the
ಅಲ್ಲ
order?
that order is passed
ಅಲ್ಲ ಈ ರಿಟ್
on
petition.
15/10/2018.
Yes, my
After
lord.
which what happened?
But para page number 4, my lord, para 3, my lord,
No,
for a
all
moment.
that we have seen. We have seen all that.
ಪ್ರತಿವಾದಿ kindly see, my lord.
That we have seen. You go to the
ಅಲ್ಲ
conclusion.
ಅದು ಯಾವ್ದಂತ ನಾನು I'll get that order, my lord.
That's no, it's not relevant. It's not relevant. On 15/10/2018,
Yes,
after noticing second post, third post, all that in para 2, 3, they said ನೇಮಕಾತಿಯನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಸಂಬಂಧ
yes.
ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಅಗತ್ಯ ಕ್ರಮ ವಹಿಸುವಂತೆ ಆದೇಶಿಸಿದೆ. The ban came in the year 2020. Between 15/10/2018 and 2020.
Yes, my lord.
Between 15/10/2018
Yes,
and the ban coming into force, if you had done, it would have cleared.
But that's so, there is no proposal, my lord, that time.
Huh?
Proposal was not there.
That's not his headache.
But let him, but that is the, my lord, we return that one proposal.
Institution plays some role. How is it of any relevance?
Proposal ಕೊಟ್ರ ಅವ್ರು.
You go to page 14. Go to page 14 of the contempt petition.
But,
Go to page 14
please, my lord,
of the contempt petition.
please.
You read from para 2 once again.
Please, please. The petitioner contends that he was appointed to the post of Group C during the year 1993 in the school of Responder 5, managed and administrated by the Responder 4. He has been paid only 250 per month and he was branded as a temporary employee. The petitioner had moved application to the first respondent for regularization of his service and also covering his post as permanent employee under the grant in aid. The responder 1 did not consider the application. Therefore, the approach to this honorable court by filing the writ petition number 201961 of 2017, the coordinate bench of this honorable court by an order dated 30th/5/2018 allowed the writ petition directing the responder 1 to dispose of the petition said to be filed by the petitioner under section 131 of the Karnataka Education Act within a period of 2 months from the date of the receipt of the order.
Now come to this one, additional document placed by the council for.
Page 5 ಅಲ್ಲಿ there is reference of
17 to 2025 ಅಲ್ಲಿ. 17 to 2025 additional document placed by the complainant. Complainant council place ಮಾಡಿದ್ರು. 17 to 25.
17, please, ma'am.
17 to
Please, ma'am,
2025.
please. That memo, ma'am.
Memo.
Please. Yes, ma'am. 17,
Come to page number 5.
please, ma'am. Please, ma'am.
Come to para number 2.
Two.
Para number.
ಪ್ರಕರಣದ
ಒಂದಲ್ಲೇ
ವಿಚಾರಣೆಯನ್ನು
fourth line my lord.
First para.
ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನೀಡಿ ಅರ್ಜಿದಾರರು ದೇರ್ಮಲ ಅರ್ಜಿದಾರರು ಸೇವೆಯಿಂದ ವಜಾಗೊಂಡ ದಿನಾಂಕ ಹಿಂದಿನ ಬಾಕಿ ವೇತನ ಪಾವತಿಸುವಂತೆ ನೀಡಿರುತ್ತದೆ. ತದನಂತರ ಪ್ರತಿವಾದಿಗಳು ಈ ಆದೇಶ ಪ್ರಶ್ನಿಸಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 200124 ಆಫ್ 2015 ಅನ್ನು ದಾಖಲಿಸಿದ್ದು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 26/4/2016 ತೀರ್ಪು ನೀಡಿ ಮುಕ್ತಾಯಗೊಳಿಸಿದ್ದು ಅರ್ಜಿದಾರರು ತಮ್ಮ ನೇಮಕಾತಿಯನ್ನು 1993ರಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಅನುದಾನ ಪಡಿಸುವಂತೆ ಕೋರಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 201961 ಆಫ್ 2017 ದಾಖಲಿಸಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 30/5/2018 ತೀರ್ಪು ನೀಡುತ್ತಾ ಅರ್ಜಿದಾರರು ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಅವಧಿ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅರ್ಜಿಯನ್ನು 2 ತಿಂಗಳ ಒಳಗಡೆ ಇತ್ಯರ್ಥಪಡಿಸುವಂತೆ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. So there is a direction to.
Correct. 15/10/2018 you disposed it.
Yes, my lord. This is disposed of, my lord. Thereafter, not proposal sent is. That is the problem, my lord.
Is it his mistake? No,
He institution has to send, my lord,
Right,
after
that's
this,
the
my lord,
institution mistake,
because he is
not
the
employee's
party.
mistake.
My lord, kindly see, my lord, he is the respondent in that, my lord. Karyadarshi of the institution is party in that 131 proceedings. He has to send the proposal to the government.
Correct.
But he sent the proposal only after the ban.
That's why the court order is given a
ಅಲ್ಲ
direction.
ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೋಬೇಕು ಇವರು. ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮೇಲೆ they have to take action.
ಆಯ್ತು.
Now also, my lord, we are
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇದೆ, ಪ್ರಮೋಷನ್ ಸೀನಿಯಾರಿಟಿ ರೂಲ್ಸ್ ಅಲ್ಲಿ.
ಮತ್ತೆ ರಿಲಾಗ್ ಆಗ್ಬೇಕಾ? ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ನೆಟ್ವರ್ಕ್. My lords,
Please, I'm
I don't know what do I do now?
if not just
Please call them. Or please call Basra Sir's number. Somebody will be there.
My lords, my lords, I appear for the state in serial number 17, my lords. Why are we not able to see the code?
It's a technical